All right, hey everybody, this is Brett Thompson again from the Thompson Law Group. So this is another Closing Ninja Classroom, also known as the Teaching Tuesday. So I got some questions from the real estate agents. I've had a lot of positive feedback, and one of the questions was in regards to the walkthrough inspection. And I want to talk about the walkthrough inspection. I want to distinguish it from the property inspection. And this is all within the realm of the Real Estate Information Network, the RAIN contract for you real estate agents and realtors. So the walkthrough inspection, that's going to be a paragraph 13 item, okay, which is subject to the cap, meaning that paragraph 13 has itemized inspections, if you will. Anything that would pop up on an appraisal, all right, that's a required repair. Anything that would pop up on your walkthrough inspection, your septic tank, the termite moisture inspection, that all falls under the paragraph 13. And in paragraph 13, the buyers and the sellers come to an agreement that the seller is going to pay up to a certain amount of money. It could be, for example, $1,000. So anything that were to show up that was a required repair under paragraph 13 items, the seller in the contract has already agreed that he would pay up to $1,000, for example, to remedy that situation. As opposed to the property inspection, all right, the property inspection and the walkthrough items are mutually exclusive, okay? They do not interact. So a contingency in the contract could be the PICRA, which is the property inspection and removal contingency addendum, okay? So that's a separate addendum, and it's a separate agreement. And in that agreement, your buyer can use a property inspector, go through there, and then you can submit, okay, in accordance with the addendum, an itemized list of requested repairs. And then after that time, it's a negotiation period between the buyer and the seller as to, for instance, how much the seller is going to kick in. How much is the seller going to perform? But that's all negotiable within the realm of paragraph 14, D1, in the property inspection. So let's talk about the walkthrough items, all right? The walkthrough items are anything that would happen during the walkthrough, meaning that what you're looking for and what you are trying to ensure is that the property is in substantially the same condition as the time that you entered into the contract. So if you entered into the contract on January 1st and you're closing on January 31st, okay, if the dishwasher worked on January 1st and it's not working when you have your walkthrough inspection on January 31st, that would be a walkthrough item, okay, because the property is not substantially in the same condition that it was in at the moment that you entered into the contract. It spells out, it carves out certain things such as plumbing, electrical issues, all the appliances, heating and cooling, that kind of stuff. But it really is anything in regards to the property, okay? The property has to be in substantially the same condition. So if the day before closing and the day before you do your walkthrough, some little kid rides by and throws a rock through the window, all right, and you had a broken window now, that will be a walkthrough item because the property is not substantially in the same condition that it was in when you entered into the contract. Another tip, if you will, do the walkthrough inspection as late as possible. I think the industry standard probably is that you do the walkthrough inspection the morning of closing, all right, because God forbid if you did the walkthrough inspection the day before closing and lightning struck the house that night or whatnot, you're not going to know about it, and you're going to close, and there are going to be some problems with the house that you were unaware of, and you have already signed off on your walkthrough inspection. So you real estate agents that are seasoned probably all know this stuff. This is maybe more beneficial for newer agents. So this take away from here. So the walkthrough, paragraph 13D, has nothing to do with the property inspection. I had a real estate agent that recently called me and said, hey, we found something during the walkthrough inspection, but the listing agent said, no, you didn't bring that up during your property inspection, so you waived it. That's not how it works, so don't fall for that one, okay? The property inspection has nothing to do with the walkthrough, all right? If the property is not substantially in the same condition it was at the time that you entered into the contract when you're doing your walkthrough, then that is a walkthrough item. I hope that was helpful, and everybody have a great day. Boom.